Now we shall discuss the expert evidence. Usually hearsay evidence or the opinion evidence has no value in the court of the law, but the expert evidence is the exception of the hearsay rule. A witness is not normally allowed to give opinion evidence because it is the judge's task to draw conclusions from the facts admitted, inferred, or proved in the evidence. There are, however, situations where judge will not have the necessary experience. So in those circumstances, experience of the expert is necessary to be taken in hand. So in most of the cases, the judge himself gives the conclusion about the facts. But there could be cases where judge doesn't have any expertise in the scenario, like scientific and medical cases or medical evidence may be taken into account. So experts of those fields are required to give their opinion. In many civil cases, the courts will want to ensure that the costs remain under control and permission will need to be sought from the court to be able to adduce expert evidence. The extent to which such evidence will be permitted will vary depending on the nature of the case. For example, expert evidence may be allowed. It may be allowed in the civil cases of small tracts, but recoverability of the cost of the expert will strictly be limited. For example, you may ask the court that you require the opinion of the expert on this evidence, but you may not be able to recover the cost that may come after you have asked for the expert. So in straightforward false claims, expert evidence may be permitted, but the court may order that the parties jointly instruct the expert and that the evidence is to be given in writing in the report. So in order to keep the cost minimum, the court can ask both parties to give their instructions to the expert, and then he may draw the conclusion based upon those instructions given by both parties of the case, and he may be allowed to give such evidence in writing. In more complex multi-track claim, it might be appropriate for the court to allow each party to instruct their own expert. So in multi-track cases, the court may allow each party to give their own expert's opinion on the case, and for those experts to prepare a report, but also to call to the court to give oral evidence. So in those cases, court may also ask those experts to come into the court and be cross-examined by the other party regarding their expert opinion, and then they be cross-examined on the content of their report. So they then give report, but they are also cross-examined to test the vitality of their opinion.